our defense team extraordinaire who are coming in and representing all of the parties. Ethan Nordine is the first co-defendant. His attorney is this guy, David B. Smith, just so we can put some names to faces. These attorneys are from New York, and I believe it's a father-son team. I couldn't find any information about Nicholas Smith, but David Smith was actually on the board of a pretty prestigious organization called the National Association of Criminal Defense Lawyers, and they do good work. And, you know, it's a good organization. They have all sorts of materials, and so he was on the board there for a while. And his son, Nick, has been doing most of the examination in the proceedings. So that's Ethan Nordine's attorney. We also have Joseph Biggs. Now, his lawyer, Norm Pattis, you may remember this guy because you've seen him around before. He was Alex Jones' lawyer for one proceeding, and he's got an interesting record. I think he had some bar issues at one point, and I think I read a headline. He was trying to, maybe get off the case and was not allowed off the case and then wanted to stay on the case. So that's who is here. And we listened to a lot of him or read through a lot of his testimony, his examination yesterday. He was cross-examining FBI agent Nicole. We also have this guy representing Joseph Biggs, J. Daniel Hull. He's a litigator. I don't think we heard much from him. I don't know if he's just filing motions. I did see his name in a filing, but he's a litigator. He's been around forever. Didn't see a lot of criminal defense experience in there in particular, but he's sort of a litigator. There are people who can just litigate kind of any field of law, and it seems like he was one of those individuals doing that. But I haven't heard from him yet. We'll see if he shows up today. Now, this woman, I really enjoyed her motions and I enjoyed her argument, and I think she's been doing a great job thus far. Carmen Hernandez, and so she's representing Zachary Real. She's the former president of that same organization I mentioned, which is NACDL, and I think she was the president, I think the 2007 to 2008 year. So very, very involved in criminal defense. I think that a lot of what we've seen from her has been very technically proficient. I'd say more so than maybe other filings. It looks like she's really got a lot of extra case law in there and it's really tight. And so she's been doing a great job. We also heard a little bit yesterday from Enrique Tarrio. His attorney was yesterday Sabino Jaregui, he's a former prosecutor, also a criminal defense attorney. I believe he's from, I don't want to misstate where he's from, but he was the person we heard a lot from yesterday. And then this guy is Nayeeb Hassan, who is also representing Enrique Tarrio. He's a criminal defense attorney from Florida. Then we have Dominic Pizzola, and he's represented by two people. This person is Roger Roots, and he was a former libertarian candidate out of Montana. And we're also going to hear today from Stephen Allen Metcalf, who did the cross-examination of FBI agent Nicole. So we still got, other defense attorneys who want to chime in and ask FBI agent Nicole some questions. And so that's who we're going to be hearing from today, so we can put names to faces, and I'll try to cue us up, and direct us about who's doing the questioning as we go through the proceedings. We also need to meet the prosecutors. So from the U.S. Department of Justice, we have 4 different attorneys assigned. We've got Jason McCullough, and prosecutors are hard to find information about. They typically lock everything down when they go work for the DOJ, when they go down into the basement and start their plots and schemes. So Jason McCullough, we couldn't find much about him. But we did know a little bit more about Eric Michael Knierson, something that the prosecutors do regularly do. And this was an interesting phenomenon that we saw when we were covering the Ghislaine Maxwell trial. We were trying to find information about her attorneys or the prosecutors who were prosecuting her. And we found that they post these announcements on the New York Times. They do it very regularly. And so that's where I got this clip. Eric Michael Knierson married another U.S. attorney, and they posted their photographs on the New York Times. I couldn't find much about Connor Mulrow. I believe he's in this photograph, but he was on the Harvard moot court team. I don't know exactly who he is, but I was able to find a little bit more about him. And then we've got Nadia Moore. She posted her information up over on LinkedIn, which I appreciate. I think prosecutors should be, if you're proud of the work you're doing in the cases that you're working on, why aren't you everywhere? Let's see who you are. Why do you have to hide behind all of the secretive closed doors? Let's see who you are. Put a name behind your work. Let's see. We do. All right. So shout out to Nadia Moore. Her stuff is published on LinkedIn, and that is the team who is going to be prosecuting the Proud Boys, right? And so we'll see if we hear from any of them as this case progresses. Now, we also want to talk about this before we dive into the actual trial that took place today. Dominic Pizzola, his attorneys filed motions over the evening. And so Pizzola, as we know, are these two lawyers. Roger Roots is going to be the individual who submitted this motion. And let's take a look at what we've got here before we dive into the recap of the day. It's a short filing, 5 pages. Pizzola is opposing the government's motion for additional trial procedures. So they submitted something in the docket some time ago, and they suggested that, Judge, when the defense starts, when their case in chief starts, which is about to come very soon, they're saying that they want the following things to happen. They say, now comes defendant Dominic Pizzola by and through the undersigned counsel and says the following, right? This is the attorney for Pizzola. He says, after the government, in the middle of trial, after the government has taken 2 months to present its case, the government now wants to impose additional procedures on us, the defense? Says the defense imposed no such control on the government and the defendant's rights are constitutionally mandated. So if the government wants to drop below that constitutional threshold, good luck. We're not going to allow it. He says, well, some of the government's proposals are harmless, true, but some are not. Some are prejudicial. And we object to the following. 1, we object to requiring a party sponsoring a witness to designate specific exhibits it intends to use no later than 36 hours prior to the time it intends to call a witness. So basically, their prosecutors are saying, look, if you're going to call a witness in and to testify, we're asking that you give us 36 hours and you give us their exhibits before they come in. Just so we have a little, we can prepare to basically so that they can prepare their cross-examinations, so that they can have the files and say, okay, well, I'm going to ask her about this map and that photo and that thing. But the defense says, hold on a minute here, 36 hours? What are you, nuts? He writes, the defense counsel cannot match the power and the resources of the DOJ. We do not have the staff, the investigators, we don't have the research teams capable of predicting exhibit needs so far in advance. Right? He's saying, we don't know what we're going to use. We're going to ask questions. This witness is going to be on the stand. I'm going to ask her this, and then I'm going to ask her that, and then she's going to say this, and I'm going to go, oh yeah, okay, how about this one? Right? And so he's got a little bit of a different approach, a little bit more organic, rather than very linear, right? Somebody might have a very linear series of questions. They just go through them. He says, Judge, in practice, defense lawyers fly by the seat of their pants most of the time, which is an interesting thing to put in a motion. Now, I don't necessarily agree with that. I mean, I think there are defense attorneys who do that, but there are defense attorneys who don't fly by the seat of their pants at all. And there are attorneys who do fly by the seat of their pants all the time. And it doesn't necessarily mean they're bad attorneys. They can be very good attorneys. They're just very good organically and naturally. And sometimes that's better than being all buttoned down and tightened up, right? You can have the best facts in the world. You can have the best case in the world, and the jury might still not like you. That's all. And so somebody who's a little bit more charismatic and can fly by the seat of their pants and can sort of dish it, just sort of operate on the fly, it's not an invalid strategy. So he says that requiring the parties to designate these things is going to be ridiculous for us. He also says that this other requirement that we introduce a record 24 hours after receiving the notice is nuts. He says we can't think of a reason for a full 24-hour limit regarding these arguments. Such arguments can be teed up and argued the morning of or during breaks or prior to presenting exhibits. So the government is very mechanical. They are very paint by the numbers. We sort of joke that they use coloring books and crayons. And those paint by number books, like put all the yellow boxes in the A squares or something, whatever. That's kind of how they do it. And they have scripts and they just run through the thing. So what happened next, officer? And what happened next, officer? And what happened next? It's just this stupid thing. So he says, we don't need to have all this linear organization. We'll just do it during the breaks. He says, any disputes, same objection about that one. He says, we also oppose this restriction about cross-examination. It violates our right to the confrontation clause, and Pizzola disagrees. Citing some case law, he says, this government's proposal is going to waste more time than it saves. Different defense teams might simply recall the same witness and examine them directly. So he says, I submit this as an alternative. He says, additionally, we request the right to put on our defenses slightly out of sequence, which is interesting, or with one witness at a time through the order of the indictment. Thus, he says, we're getting ready for what the defense wants to present. That's going to be starting next week. He says one witness by Nordine, one witness for Biggs, and so on. So they want to just sort of run the table. You go first, I'll go second, then you go third, then you go fourth, and you go fifth. Now, this is interesting. He says this mechanism, rather than one going at a time, one person presenting everything and then turning it over to another person and then another person. He says this will prevent defense attorneys from becoming exhausted or bored from idleness. Respectfully submitted, Roger. What? Bored from idle. It's true. You don't want to be bored from idleness. I guess that's true. It's just interesting to put in there. So that is the motion that got filed for Dominic Pezzola, saying we don't want to be bored and let us not become exhausted. So we'll see what the judge says. Of course, we're going to turn into the details the day of the trial. But that was Roger Roots on behalf of Dominic Pezzola.